Spokane resident Brian Hansen proposed a city initiative that would have triggered a major crackdown on encampments within city limits, even when no shelter beds are available. In November of 23, the initiative to ban camping in certain locations was placed on the November general election ballot. Jules Helping Hands and Ben Stuckart, advocates for the homeless, are now appealing the decision, arguing that the initiative, 1. seeks to exercise powers reserved solely to the Spokane Council, 2. conflicts with controlling state law, and 3. is outside the scope of local initiative power because the measure is administrative, not legislative. Let's take a look at the arguments.
If it pleases the court, my name is Noel Lowney with Smith & Lowney, and I am representing appellants Jules Helping Hand and Ben Stuckart, both homeless service providers. Statewide initiatives have a unlimited scope, but the scope of a local initiative like we're dealing with here is limited by state law. And so there are a well-established list of rules about what local initiatives can and cannot do. And they apply to everyone, conservative initiatives, progressive initiatives. Unfortunately, sometimes people who write initiatives do not follow these rules, and that's the situation we're in here. As our briefing shows, the Homeless Camping Initiative, sponsored by Mr. Hansen, violates at least 4 of those rules, and any one violation is enough to invalidate it. I'd like to quickly just go through the history of camping bans in the city of Spokane. The zoning code, the Unified Development Code, it regulates camping on private property, allowing camping for up to 14 days and having a special permit process if one wanted an extension. On public land, there's a different history. Until 2022, there was a blanket prohibition for any homeless camping on public lands, and public lands was defined very broadly. However, the Ninth Circuit's Martin versus Boise decision rendered such camping bans largely unenforceable unless the city has enough shelter spots available, which it doesn't. But Martin allowed cities to develop sort of never camping zones where there was a good reason for preventing camping at all times, regardless of shelter availability. This was a major source of contention among the city council and with the public. Some wanted the never camping zones to be small, some wanted them to be large, and ultimately the mayor brokered a compromise with the city council, and that is the current law. In comes the initiative, which seeks to upend that compromise and expand the never camping zone to much of the city. Because it is on the ballot now, the injunction has been denied. It will be on the ballot and it will take effect immediately if it were to pass. It means that homeless service providers like my clients and unsheltered individuals are already being impacted. And if it were to pass, the city would be embroiled in litigation. And if the initiative were to be declared invalid, then of course we would be left without a camping ban at all. Nobody knows that. But what we do know is that the city and taxpayers should not have to spend money on this initiative because it is invalid under almost 50 years of precedent. And again, there are 4 different ways, and each that it is invalid, and each would be enough to invalidate them. First, yes,
and we have precious little time here today, so I want to focus our arguments. I am not overly convinced about the arguments that this is a zoning ordinance. Typically, zoning ordinance goes against a property owner, not somebody occupying it. It seems like this is more of a police power. Likewise, given that it's a police power, it doesn't seem to be part of the city's initiative to address homeless, the unhoused persons. It is more of a public safety measure. But where I'm concerned is the legislative administrative debate. I think the debate is whether or not this would create a new policy, which is what the initiative proponents are saying, in that there's not before been a blanket prohibition on areas near daycares or schools, or whether or not it is interfering with the administration of an existing policy, meaning a policy, as you've articulated, to enact some blanket prohibitions, but blanket prohibitions that comply with the Martin case. It seems to me, and we have a tragedy of the commons issue here. We have so much land available and that can be protected. And the city made a decision as to what its priorities were. And there's an argument that you're making, if I understand it correctly, that this is interfering with that compromise. Can you focus in on whether or not this is legislative or administrative?
Yeah, I would. I'm happy to start there. I mean, it is a complicated area of the law, but the courts have basically said that once that you develop this sort of a existing policy and you are well down the road in implementing it, then it really is too late to use the initiative process to try and undo that compromise. And the cases that we've cited to, including Our Water, Our Choice, and Spokane Entrepreneurial, are those type of cases, as well as the Rwanda case. Now, it is clearly a situation here where there is a very complicated issue. And I think it is in these particularly complex issues where the courts have struggled and ultimately ruled that that these are administrative decisions, because there needs to be essentially some deference to continuity. And that if there is going to be a change, it has to go through the same rigorous process. And here it did not. There was a compromise that addresses both these competing interests, but really also, most importantly, was what is going to be legal and enforceable under the federal Constitution. And so all of these things went into the mix, and ultimately to undo it is administrative under the precedents that we have cited.
Mr. Lowry, let me ask you a question, though. It's my understanding that in deciding this initial validity of the initiative, we don't get into the issue of whether it's going to meet the constitutional test afterward. That's not part of our analysis, correct?
That's correct. That's correct. Here, what we need to just look at is whether it interferes with the powers that have been delegated to the city council or to other stakeholders, whether it interferes with the coordinated permitting decision-making process under state law, or again, whether it's administrative.
How would you characterize the original ordinance?
The original ordinance was certainly legislative. I don't think there's a question about that. But just because the first decision is legislative does not mean that all future changes are. And so I think that is the rules that have been espoused in those decisions. Like, nobody questions that the original decision to build the I-90 corridor, for example, was legislative, but to try and undo it was not okay. Same with the fluoridation decision, same with the others that we have cited.
Mr. Lowney, I'm just wondering, maybe I don't see this the right way. I see your argument, or possible argument, the ramifications of your argument, as a collective action problem or a tragedy of the commons problem, where there's only so much public space available in the city of Spokane for unhoused people to live, assuming there's no shelter space available. We're not getting to the legal issues of that, but that's the concern that the city had. The city prioritized viaducts and areas near existing shelters as being areas where they want to take that out of the mix, but they needed to leave enough extra space. I think, as I see it, the concern is that the initiative proponents want to take away additional spaces. And if everyone did that, there would be no space left. When you're dividing up a finite resource, and priority has been made by the city as to how to divide up that finite resource, knowing the rest of it has to remain in place, it's starts to me to be a problem that shouldn't be left up to the people, because everyone's going to say, not in my backyard. Everyone's going to say, I want a different priority. The city's stated what its priority is, and it would be unduly administrative interference with their administration to start carving out additional pieces. Is that the right way to think about it?
Well, I
don't hear you saying
that. I think that really is part of it. Like, if you can say not within the 1,000 feet, you could also say not within our city altogether. And I think that's what happened here, is that at a certain point, it went from something that was just a purely local problem to really a statewide problem. And when the state legislature decided that this was going to be a statewide problem, that it was a statewide crisis, they also realized that there needed to be some way to address it that wasn't so politicized. So, for example, they passed the act that we talk a lot about in our briefing, that required coordination. It required expert input. It required stakeholder groups. And, at that point, when the state legislature says, yes, you can all have input, but you need to do it through a particular process, and it needs to be a fact-based regional process. At that point, it no longer can be an initiative issue. Like, this is not to say people like Mr. Hansen should not be involved in this process. Everybody needs to be involved, but they need to be involved through the process that the legislature set up. They cannot use an initiative to run around it.
I have a question for you. If we disagree with you as to RCW chapter 4381(5)(c), I see that as a comprehensive, yes, local governments are supposed to engage in this comprehensive approach to addressing homelessness. Quite frankly, I don't see this ordinance being part of that. This ordinance appears on its face to be a public safety ordinance. It's not looking to solve problems of homelessness. It's looking to solve public safety issues, realizing that there's some limitations on how much land can be not made available for unhoused persons, but the primary purpose is not. There could be a whole separate effort to address unhoused persons, to have some housing built, to have facilities made available, etc. But if we disagree with you there, does that control the administrative legislative argument? I hear you saying that those two stand and fall together.
Yeah, no, I'm saying that those are two totally separate arguments. But I would say, in response, Your Honor, to your statement that this is motivated by public safety, that very well may be true, but I would draw your attention to the Yes for Seattle case, which really was an initiative effort that had nothing to do with the Growth Management Act. It had everything to do with protecting.
You're into your rebuttal. I'm sorry, I should have warned you earlier. You've got about 2 minutes left.
Yes, it had nothing to do with the Growth Management Act. It had everything to do with protecting creeks. And yet still, the Court of Appeals, and then deferred to by the Supreme Court, said, no, you cannot go into these areas that are already carved out. So police powers is not enough. I would like to just also, I'll reserve the last 2 minutes. Thank you.
Okay, you've got a minute 30 left. Respondent.
Good morning. Thank you, Your Honors. My name is Mark Lamb with Carney Badley Spellman. I'm here with my colleague Ken Hart, who's a resident of the city of Spokane, and the respondent Brian Hansen, our client. I wanted to begin by saying there are two matters in front of the court, and so what I would propose to do is to address the motion to dismiss that's before the court first.
Go ahead.
It's our position that the motion to dismiss and the procedural history of this matter is a case in point of why pre-election challenges are not appealable. What the appellants in this matter seek to do is to overturn the results of an election in which people are presently voting. This court should immediately dismiss this appeal with an opinion to follow to remove the cloud that appellant has placed over this election, seeking to tell citizens of the city of Spokane that their votes will neither count nor be counted.
What statute? Are you relying on 29A 68011?
Yes, Your Honor.
I read that statute and I just can't for the life of me understand why that applies here. It talks about a wrong name on a ballot. an error in printing a ballot, the name of any person. It doesn't talk about that this is not the proper, it's not the proper type of initiative either, because it's a zoning regulation, it's administrative instead of legislative. Why does this fall under 29A as opposed to the Declaratory Judgment Act?
That's a fantastic question, Your Honor. And it's actually a question that is best pointed to the appellants, because they're the ones who use the statute to get expedited review under this. The appellants had a choice.
But you're the one bringing a motion to dismiss.
Right. Well,
Okay.
correct. So we're bringing the motion to dismiss because this is the statute that they brought their motion under. They brought the motion.
Well, they also
under,
cited the Declaratory Judgment Act, didn't
They
they?
did, Your Honor, except that's subsumed within it. They specifically sought expedited procedural relief, and under both Hatfield versus Greco and Parker versus Wyman, when you do that, the decision of the court is final. It's also instructive that under that pre-election statute, they could have gone to any court. They could have come to this court. They could have gone to the Supreme Court. It specifically allows you to do a pre-election challenge for the purpose of determining what is on the ballot. This case is instructive as to why whatever court you go to, that decision should be final.
Well, it's on the ballot. We're not going to change that.
Well, true, agreed. It's on the ballot, but I mean, they're seeking to have this election voided. I mean, it's instructive as well that the appellant doesn't tell you precisely what relief they're seeking. Are they seeking to tell the county auditor not to count these votes? Are they seeking them to destroy these votes? What exactly is it that they're asking for? They're asking you to take a valid election and void it. The whole purpose of having a pre-election challenge and the whole purpose of that statute, if you avail yourself of it, you don't have to. You can say, you know what, I'm going to bring an action under the Uniform Declaratory Judgments Act, or I'll bring and I'll take that and I'll move to shorten time, or I'll take it after the election. That's not what they chose to do. They emphatically and repeatedly insisted that the trial court act under an expedited proceeding under the statute. And when you do that, you take the bitter with the sweet. The sweet is you get your expedited relief. The sweet is if you win, you can have it removed from the ballot. But in this case, Your Honor, as you guys are well aware of, in terms of the procedural history, you had two different rulings in a single day where the voters of Spokane and the auditor was left with not knowing within a 24-hour period whether this would be on or off the ballot. It shouldn't be a case, and there's precise case law, it shouldn't be a case where it's just the last party to get a favorable ruling before the ballots are printed wins. That's precisely why there's a finality rule when you invoke the statute. You get expedited relief, but you're stuck then with the finality rule. You cannot then seek an appeal of that. And that's consistent with Hatfield v. Greco and Parker v. Wyman. Appellants do not cite a single case, not one case, that says when you use both the pre-election statute challenge and the Uniform Declaratory Judgments Act, that you're entitled to simply step over after you lose the appeal and say, well, I'm abandoning that now and doing it.
Do you have authorities that say that when you cite both, we basically one trumps the other, even though one's not facially applicable? So,
well,
I mean, they could bring a challenge, a post-election challenge, saying this is not the proper subject matter, apart from constitutional issues. They could bring it under declaratory judgment. So we have that before us.
I would argue that they could not, that they would be barred by collateral estoppel, Your Honor, because they brought the issue, they chose the forum, they chose the expedited relief. And if that's what it means, if the statute really means that all you need to do is cite it under the Uniform Declaratory Judgments Act, then the finality rule, which is, there's two Supreme Court cases that say, look, the finality rule applies once you invoke it.
How would collateral estoppel apply? Because there's not a wrong name on the ballot. So we couldn't say, it was determined the wrong name was on the ballot.
It's an error again, that's the argument they made. They said it's an error in printing, and because of the error in printing, we're entitled to do that.
But it's not collateral estoppel. I mean, the fact that the argument of it was a substance wrong or right has not been established. It might have been, I don't know. I mean, collateral estoppel usually is not so formal that something that was never litigated and decided becomes litigated and decided because of a statute that had nothing to do with it.
I think that's a great question, Your Honor. However, in this case, they used the pre-election challenge to get to the substantive merits of their argument. That's what, if you read the trial court decision, that was what was litigated. And he specifically said, I'm issuing this order under the pre-election statute. And he addressed each and every one of the substantive arguments that they made at the trial court and that they're making here today. I don't want to take more time on this. I'd like to get to the substance of what is being argued, but I think you understand my argument. With respect to the issue of legislative versus administrative, because I think I want to address the court's concerns on that. Article 1, Section 3 of the Spokane City Charter says all power of the City Council is subject to the control and direction of the people at all times. The appellant's point is that if a legislative body reaches a compromise, then it is somehow beyond the power of the initiative, of the people's initiative. That argument would essentially vitiate the entire power of initiative if that were true, because every action, and I can say this as somebody who used to serve on the city council, every single legislative action is a result of some form of compromise. What they're arguing here is that the people's right to have an initiative is blown away simply because the city council reached an agreement.
Because they already acted. What I read before was just quoting your brief that says that the initiative would create a new policy and not exceed the people's initiative power by interfering with the administration of an existing policy. So as I see it, it's tough. I mean, and the case law says this is a tough tough issue because it depends on how you look at it. Is this a new policy or is it interfering with the administration of an existing policy? In your brief, as I read it, you admit that if it interferes with an existing policy, it's administrative.
I think that's not what our brief maintains.
Okay, because I just quoted your brief.
Yeah, no, I think that's not what our brief maintains. So when we go to the section of code that's implicated, which is section 12.02 of the Spokane Municipal Code, in that there is the policy of where should encampments be banned, where should you never be able to have an encampment. There is then an extraordinary detailed method of how that should be enforced, like under what circumstances, whether somebody is being cited for this, can they be taken to jail? The answer is no, they can't be taken to jail unless they have an outstanding warrant for another matter. It then goes through an analysis of in terms of the availability of shelter beds, etc. That is the administrative portion of the code. That is how you administer a policy choice as to where in the city you should allow camping.
So if this ordinance or initiative had said, under these circumstances, we're always going to mandatory arrest.
Yes, Your Honor, that would be an administrative issue, and that would be prohibited by the administrative legislative distinction. What we have here is a policy of where these camping bans are allowed. The city council arrived at a position on that. The people, as they're allowed to under the Spokane City Charter and as they're allowed to under Washington state law, modified that policy position. They're allowed to modify policy. They're not allowed to modify administration. This initiative is literally 27 words. All it does is modify the scope of the never camping zone within the city of Spokane. I think it's also informative to understand, because I know the court has referenced this, if we're fair and we're being honest here and transparent, both sides have engaged in a merits argument. It's not appropriate in a pre-election review. And a quick glance at the calendar would reveal this is a pre-election review. We are 2 weeks before an election. The election has not occurred yet. We're still in the pre-election period. Regardless of the first line of appellant's brief saying this is a post-election review, it's not. People are voting right now. But the Ninth Circuit held that a city may not prosecute a person for camping on public property if they have no option of sleeping indoors and not a single place where they can lawfully be. That's the Martin decision at 920 F30 617. But the Martin court made clear it was in no way indicating that a city must allow anyone who wishes to sit, lie, or sleep on the streets at any time and at any place.
Sure. I mean, I guess it just raises to me this tragedy of the commons issue. I mean, I could see 10 different groups having initiatives that would cover the entire city, because one group would say, I don't want near schools. Another group might say, I don't want near bus stops. Another group would say, I don't want near stores. And then you have no place available. Whereas the city, in saying, okay, we want to have places where it's never camp. We want to have places. We realize we have to have some places where we can't do that. So we have this tragedy of the commons issue where if you let everybody to their own devices, we won't be able to administer this finite resource. So, I mean, apart from reading your brief, I read the Our Water, Our Choice case, which says that the distinction, generally speaking, a local government action is administrative if it furthers or hinders a plan the local government or some power superior to it has previously adopted. So what they previously adopted was this plan that we're going to have certain spaces be never camp, realizing that we have to leave other spaces open. And so your group wants to come in and further limit the never camp. Isn't that right?
No, I think, Your Honor, to read Our Water, Your Choice then would say that there could never be, for example, a referendum. You could never say, hey, should this policy be repealed or not? If the conclusion of our water, our choice is once a city council has staked out a policy position, it can never be modified.
Well, it's always a matter of, this is what makes it hard. It depends on how you word it. If, you know,
Right.
if it's something new,
That's-
let's say that the city just, you know, hadn't taken action on folks camping on public grounds, then there could be an initiative saying, you know, you can't camp on public grounds. It would be new, something new that wasn't spoken on.
But I don't think, I think if that were true, if once a city council has staked out a policy position, the citizens could never legislate. That would vitiate the power of referendum. And I think that's not the case. I think the issue really is whether it's a policy choice or whether it's the administration. Here in section 12.02, none of the administrative elements of that statute are touched by this initiative. All this initiative touches on is the policy question. Your Honor, I take your point with respect to the tragedy of the commons, and I think it is, you know, it's a question to follow down the road. But I would submit to you that that is a question, that is a legislative and a policy question that is appropriately in front of the citizens of the city of Spokane. And that's not the case that we have in front of us. The case that we have in front of us does not remove all of the areas where people can camp. What we have in front of us is a restriction that has been acted in the city of Los Angeles and the city of Portland as well, which is to say, just as they said, as the Martin court said, there are certain areas where it's better to have camping than others. And there are certain areas where we should be able to have reasonable limitations on that. It's also important to look at what the purpose section of section 12.02, it says the purpose of this chapter is to regulate and control the obstructions of public right-of-ways in the city so that those right-of-way remain accessible and safe for their intended public use. What the citizens are doing and what Mr. Hansen is doing in this initiative is to say, look, I believe that that is a valid policy debate to have. And it is a policy debate that is occurring right now as we sit in this courtroom. Right now, the people of the city of Spokane are making that policy decision. They are casting their ballots. Ballots have already been cast in this election. What the appellant is asking this court to do is an extraordinary act of judicial activism where you would then direct the county auditor to throw out legal ballots, to throw out ballots that have already been cast in election. We live in an era, we live in a time where people's faith in democracy and faith in the courts is routinely called into question. I can think of nothing more corrosive to the democratic process than to tell people your vote doesn't count. Your vote will not be counted because we've reversed our decision of earlier this month that it should be placed on the ballot. As a matter of policy and as a matter of substance, one can come to different conclusions. If the appellants in this case wish to challenge this under the Martin decision, just like they can challenge the city council of the city of Los Angeles, just like they can challenge the city council of the city of Portland, Oregon, they can do so. But that, Your Honors, is a different challenge. That is a constitutional challenge on the policy merits of this proposal. It is not a challenge with respect to the scope of this initiative, which is squarely within the historical prerogative of the voters of the city of Spokane, which under the Spokane City Charter are allowed to, at all times, by initiative, exercise control over the direction of the city council. It is clearly in this thing, you have both administrative and you have policy elements of section 12.02. The only thing the 27 words of this initiative touch is the policy decision of how broad the scope should be. It would be an extraordinary leap to tell the voters of the city of Spokane, your opinion on this critical policy matter does not matter, and you do not have a right to spoke. And ballots that you have already cast should not be counted and should be thrown out. That is the relief that the appellant is seeking. That is what he's asking this court to do, is for you to tell the county auditor who is represented here today, don't count legal votes.
But if the initiative is illegal, it's our duty to tell the county auditor that.
I think if you believe the initiative is illegal, then the court can take that step. The initiative is not illegal,
Okay.
And that would be an extraordinary exercise of judicial.
Stating that it's our job sometimes to do the unpopular thing.
To me, this would not be unpopular. This would be unlawful to throw out the people's votes.
I understand your position. Thank you.
Thank you, Your Honor.
Rebuttal?
Yes, thank you, Your Honor. I will rely upon my briefing on the motion to dismiss. On the merits, the hearing examiner of the city did provide some recommendations. And one of the things that the hearing examiner did state is that this may be invalid as an administrative issue. And that is something that Mr. Hansen decided to go forward anyway, and it's not extraordinary for initiatives to be subject to judicial review either before or after they are enacted. That is just part of the process. The administrative issue, I think a big argument made is that this does not repeal the decision that was made, and that's on page 51 of Hansen's brief. But in fact, when you have a compromise and a complex issue, making a major change to it is fundamentally a repeal. And I'd like to just conclude by asking you all to, despite your skepticism about the zoning issue, respectfully, it is a very important issue. If you agree that this initiative will change the regulation of camping on private property, which is really the only plain language conclusion that you will be able to reach, well, then the courts have said that you cannot amend an existing zoning code by initiative. But it doesn't even have to be a zoning code. I mean, what's important here is that the city council has the exclusive authority to do land use regulations. And under Protect Public Health, once they've done that, you cannot use an initiative to tweak, modify, repeal that. And so I would just
you're over your time now. We will definitely look at that issue. Thank you.
Thank you, Your Honor.
Following these arguments, the court determined this initiative was legislative and the previous decision was affirmed. Please let me know what you think of this case in the comments below, and if you like this video, please hit subscribe for new arguments every week. Until next time.